Hello and good evening. You're watching DD News. I'm Gautam Roy, and tonight in late edition, we're going to closely examine the provisions of the new Juvenile Justice Bill, which has become an act today after being passed in the Rajya Sabha. It will come to force after presidential assent and has provisions where offenders aged between 16 to 18 years can be tried as adults if they commit heinous crimes. The new law had been a long pending demand from a large section of the society ever since the gruesome December 16 Delhi gang rape and murder case. One convict in this case was aged between 16 and 18 years when the crime was committed and recently walked free after spending 3 years in a reform home.
Parliament has finally responded to the outrage over the release of the juvenile convict in the Nirbhaya gang rape and murder case. Cleared by the Lok Sabha earlier, Rajya Sabha passed the Juvenile Justice Bill 2015 today. It clears the way for the replacement of the previous law, which kept offenders aged below 18 years in the juvenile category, ensuring lighter punishment compared to adults. According to the provisions of the new law, offenders aged between 16 and 18 years who commit heinous crimes like rape and murder can be tried as adults. Offenders aged between 16 and 18 years committing serious crimes can be treated as adults only if they are arrested after completing 21 years. 16 to 18-year-old found guilty of committing heinous crimes can be jailed but cannot be given life or death sentences. Juvenile justice boards and child welfare committees will be constituted at district levels. Juvenile justice boards will decide if 16 to 18-year-old offenders will be sent to reform homes or tried as adults. Penalties for cruelty against children, offering narcotics to a child, abducting or selling a child remain unchanged. Heinous crimes are those where the punishment is jail for 7 years or more. Serious crimes entail a jail term or 3 to 7 years. The need for harsher law was felt in recent years as the number of crimes committed by juveniles has increased sharply. In 2013, juveniles committed a total of 31,973 crimes. In 2013, the figure went up to 35,861 crimes. And in 2014, crimes committed by juveniles climbed up to 38,563. What raises an alarm is that more than half these crimes were committed against women. The number of crimes committed by juvenile against women went up by 92% between 2012 and 2014. The data also points out that the number of heinous crimes committed by juveniles in the last 10 years has gone up by over 50%. It can only be hoped that with the new law, crimes committed by younger offenders can be curbed effectively.
All right, let's look at the bill now that has become law. We have with us Priya Hingorani. She's a Supreme Court advocate. She represented, in fact, Nirbhaya's parents when the original act was challenged in the Supreme Court. And we also have another lawyer, Anant Asthana, who's in fact, not in favor of the bill as it is becoming an act. Now, first with you, Priya, what is your submission here about this particular bill? Do you think it will be an effective instrument in curbing these heinous crimes by juveniles?
No, not at all. I am not in favor. For me, the age is irrelevant. Whether it is 16, earlier it was 16, in the JJ Act of 2000 they brought it up to 18. Now they are again talking of bringing it down to 16, or they are bringing it down to 16
for heinous crimes.
For heinous crimes. According to me, and the way we had challenged the constitutional validity of the Act, saying that the whole premise of the Act, the JJ Act, is wrong.
This is the 2000 Act.
2000 Act, or even for that matter the 2015 bill, amendment bill which they are bringing. The whole premise is wrong because under the Constitution, the courts have been given the power to try matters, right? There can't be an act which gives a blanket ban to all these acts which come in place. You say that saying that you cannot follow the IPC or the CRPC, the laws. So here the intent and the maturity of the child who commits the heinous crime has to be looked into.
Regardless of age.
Regardless of age. When a juvenile is committing a crime of rape or murder, the court has to, it is the court, a judicial court, which under the IPC and CRPC has the right to look into the mindset, the maturity, the level of his understanding, and then decide whether the matter is to be tried as he is to be tried as an adult, which is already existing in our laws, or then to send it to the juvenile board. Because the juvenile board, though may have a magistrate or other members of it, does not apply its mind judiciously. Even the Supreme Court, in the matter which we had challenged the act, said the juvenile board only does an inquiry. It does not do a trial.
Okay.
There is no question of punishment under the JJ Act. So according to me, whatever is happening now in the amendment bill or even the act, it does not serve the purpose.
I see. And what is your standpoint, Mr. Asana? Because you feel that this new act in itself is not fair to those who might commit crimes even if they're in the age of 16 to 18, where it is felt in the case of certain crimes which are heinous crimes, rape, murder and others, that they can be tried as adults.
Yeah, in this bill has many provisions which have problems. The most strong criticism is about this provision which is called judicial waiver. It's a Western concept whereby you waive a category of children. First you identify them and then you waive them to the adult criminal justice system. So my position is that whatever options you have to exercise, you exercise them within the juvenile justice system. Don't waive children to adult criminal justice system, because it doesn't work. Globally there is a trend against judicial waiver. For example, in the United States of America, they had the harshest law. They had death penalty, they had life imprisonment without possibility of parole.
For even younger than 16 children.
Yes. What they have done in last 5 years, that they have abolished death sentence for children. They have abolished life imprisonment without possibility of parole. Recently they have abolished life sentence also. And now they are again moving back to the reformative approach which they had abandoned in 1980s.
Okay.
So when we have an example before us, and America is worse when it comes to juvenile crime. So they experimented with judicial waiver.
I understand what America has done, but India is not America. In India,
it's not.
There was a growing outcry, especially after what happened in 2012 with Nirbhaya, the rape victim we call Nirbhaya. That led to a huge outcry for even the juvenile facing the force of the law, just like the other offenders in this particular case, which I think was the origin of this bill. And now that it will be an act, that demand at least will be met.
No, it's not correct that the origin of the bill was that. Origin was much before under UPA government. Originally it was UPA government which brought the idea of reducing the age from 18 to 16. A bill was almost ready.
Okay.
But when the last leg of the discussions were going on, they had very intensive discussion going on with the sector, with the people who work on child issues and criminology and all that. And then there was an opinion that maybe that's not the best thing to do.
Okay, but what happened in 2012 revived the school of thought that
no,
perhaps
but even the Justice Verma committee, in fact, was not in favor of reducing the age from 18.
Yes.
And they categorically said that, because that was also one of the issues which came up before the Justice Verma committee. And in fact, that was the main issue, and that's why the other amendments came through. Punishment, voyeurism, stalking, all the other new acts, sexual harassment, workplace, all those sections were brought in after that. But see, again, I don't know why there's been talk in the debate. They were saying there's been 3,000 crore fund there which is lying unutilized. None of the states have the kind of infrastructure or the protection homes the way they should have been, presuming that the child is put into a juvenile home. How is it and why is it that this juvenile is coming out, as the IB report says, radicalized? Why? What went wrong in these 3 years? 3 years he has been in this protection home. It should have worked the other way around. Now they are saying the IB report says he's radicalized, and now they should
find if there is such an IB report, we're not sure.
Yeah, we're not sure. I mean, that's what
been cited
absolutely
as a reason.
Yeah, a reason. So the thing is, the juvenile himself says, I'm fear going out into the society because I may be lynched or whatever may happen to him. The thing is, the way our infrastructure is, the way the governments, our biggest problem is the political will to put these structures in place.
Exactly.
There are rules. The rules also have got ambiguity. unfortunately in none of these states in India have got a proper structure in place where these juveniles can be given psychological treatment, counseling, proper education, making them realize what they did was wrong.
So that's
how
something
can they
you're
improve.
saying needs to be done even after this
Yeah,
law
so that's not
coming to be.
that is not what is being addressed by the political parties or by these respective governments in each state.
And are you also saying that had this been done, all these things that you're saying,
Yes.
a system had been created where there is a genuine chance of reform,
Yeah.
changing the law might not have been necessary?
Again, I come back to it that according to me, age is immaterial. I
Okay.
am not talking about age. Tomorrow a case will happen, and it has happened. Today's paper talks of a 15-year-old juvenile in the Meerut case where
Yes.
the Nepali woman was gang raped. So every year you come across so many cases. While we had been debating this, 11-year-old, 12 years old, as you said, 7-year-old. So age is not the issue.
Yes.
The maturity
You're referring
level.
to the Rohtak case.
Yes, Rohtak
Yeah.
case. So age is not the issue according to us. That was our argument before the Supreme Court on behalf of Nirbhaya's parents. Don't go by the age. Age is immaterial. Go by the maturity level, the intent, the acceptance of the fact that he knew exactly what he was doing.
And do you buy that argument, or are you completely against this sort of line of argument as well, that these people feel that
This
16
argument
to
has a
18 is
problem.
not something that one should really stick with, as long as there are other factors that make the crime as heinous as perhaps or even worse than what happened in 2012 in December?
See, 2 points I would like to make. The argument of deciding what should be done with a person based on his mental maturity. That argument is risky, because once you bring that into the law, for children you apply the same logic. Tomorrow an adult will stand up and will say that even though I am 30, but my mental level is 16.
Would you like to respond to
That
that?
argument has a danger.
Not at all. I mean, he's an adult. He's jolly well supposed to know what he's doing. And I mean, you have psychiatrists who will be verifying in court. The court has the power to call anybody and say what is his mental state. When they do the bone density test to find out the age, the doctors can always come and give it. I don't buy that argument. See, nobody is, I think, for a moment saying across the spectrum that you send them to the hard jail or you put them in a prison where there are hardened criminals. There has to be
That's not what will be done even in
even
this
if-
case when
yes.
the new law comes
yes,
into being.
absolutely. That's not what the issue.
There's talk of bostels.
Yes, bostels, but at the same time, where is the infrastructure? Where is the system in place? They have the money. They need to put the system in place. Why hasn't it been done in these last 3 years? Why hasn't it been done for the last 20 years? You know these kind of crimes are happening in our country. We know these are the issues which are before us. But why are the governments not acting?
Anand, could you just tell us a little bit more about what the minister said in the House today about bostels? How will they ensure that this person, although he or she may be tried as an adult, will not land up in the same environment as hardened criminals in jails? And why do you think even that is not a solution? In your view, that is not a solution?
Yeah, see, that's not a solution, because the intention of the bill is to get rid of children, a certain category of children. So there is no concern
Get rid
for
of
children.
in the sense
Like just
that
throw them,
just pack them off.
throw them into the jail. That's the intention of the bill, right? Now these ad hoc arrangements like Bostel, even in this present law, there is a concept similar to what minister is proposing in the bill, which is place of safety in the existing law. Now, apart from Delhi, most of the place of safeties are actually functioning in the jail. In Delhi also it used to be in the jail, but Delhi High Court took judicial cognizance and said that you cannot have a place of safety. But if you go to Rajasthan, go to some other places, most of the place of safety which have to keep children are functioning from within the jail. This
Okay.
is going to happen with the bostels also. Government cannot create bostels overnight.
You're not being presumptive here that this is what will happen?
No,
in the
because
case
this is
of
the
bostels as
reality.
well?
This is the reality. We have seen how place of safety is working. This is
Okay.
how the bostel will also work. What my concern with the bill is that though it thinks that it has done the best thing, but actually it has made the situation worst. For example, when the POXO Act came, we were saying, constantly warning the government, please do not increase the age of consent from 16 to 18.
Okay.
But because there was a panic of increased sexual offences against children, you brought out a law, POXO, which is having very draconian provisions, but in the name of child sexual abuse, you did it. Now there is an alarm against that law everywhere.
Okay, we'll talk about that
In Juvenile
separately. But
Justice
Priya,
Act bill-
what is your view on what Anant just said?
See, I don't, again I say, whether it is Boston or whether it is a correctional home, whether it is a remand home, the infrastructure has to be there to ensure that whatever the child is there, whether he is tried for a heinous crime
And
or for a
infrastructure
ordinary
is not
thing,
just brick and mortar.
is not. It's
Yeah.
not brick and mortar. There has to be other things in it which go side by side. But when it comes to trying now issue what in our country or whatever what Nirbhaya's parents are saying, what is the issue which is being brought out again and again is what do you do? How do you try the person? Do you try send him just to a juvenile board, which is just a magistrate and two people who just inquire into it? There is no concept of a punishment, and you just send the person as a ticketless travel. A child is in a remand home, or a robbery a child who has committed robbery is in remand home, and this person who's committed a murder, they are in the same remand home and they are interacting with each other, and there is no way of telling the child where you have gone wrong. According to us, the IPC is very clear on it. According to us, the judicial mind of a judge has to be taken in first instances where the judge has to come.
Understood. You've made that point.
Yeah, I've raised that point. So again and again we are all going down. The debate also says that the society has changed. So many crimes are happening. One after the speaker has said that, but they are not talking about implementation. They are not talking about infrastructure.
Well, we clearly see that crimes committed by juveniles, especially crimes against women, they've seen a huge increase. But
I mean, media has played an amazing role in the last 3 years. I would say that to bring out these cases, whether the electronic or print media is reporting, the more and more cases are being reported, more and more FIRs are being registered.
Yes.
But then again, what is the level of investigation? Very poor. No police reforms. There is the whole infrastructure. Again, it comes down to the political will. It comes down again back to that. Why aren't the police reforms being brought out? Why is the investigative agency not given full training and equipment to do the investigation properly? Why don't we have, why is there so much corruption in the police force? I mean, these are all issues again.
These are all wider questions.
Wider
which,
questions, yeah.
I guess a bill or a law, a new law cannot really
but
address.
then all of them get affected. All these kind of cases do get affected. Because
as far as this fear,
the
Anant,
delay in courts,
yeah.
I mean the delay in courts, that's why the girls and the families then become
now
hostile
you have this
witnesses.
trend of fast track courts
Yeah.
in case of sexual
But then
offences,
there's so many
even then
cases pending before the
there are
courts.
delays.
Yeah.
Yes, but Anant, this apprehension that it will be misused, in case of people who are adolescents who are consenting. Do you feel that that is a fear that is real, or that's something that's been addressed now?
No, it's not.
in the
It's actually going to be very difficult for that category of 16 to 18, particularly in sexual offences where the law
That's why
says
there was a
it's
demand of
rape.
an age gap, but that's not.
See, I tell you the danger. The way the judicial waiver has been conceptualized in the bill, it requires the Juvenile Justice Board to judge the circumstances and the role played by the child even before allegations made on
some
him are
people are also
proved.
saying that the JJBs have too much of discretion.
No, it's not that. See, the judicial waiver has to be exercised by the board even before the police has filed the charge sheet. So you are going to judge a person and decide whether whatever he has done is so heinous
Without all
without
the
there
evidence
being an
being there.
investigation,
That's
without
exactly what I'm saying. And
without
that's the
the
thing.
facts being proved.
Is the JJ board competent enough to decide or look into the investigate into the matter? What the job or is of the magistrate, or what is the job of the court, a judicial magistrate sitting in his judicial capacity, where he has every evidence, every substance investigative report before him to use his judicial mind to decide. That power they are trying to give to the the JJ board, which is not competent enough to decide it.
Okay.
I wanted to complete that.
I'm sorry. Please, Anand.
So if there is a person who has been alleged to have committed rape, and the description given by the police is that the boy kidnapped the girl and then 4 guys just raped, though the counter version may be that the boy and girl had a relationship, parents caught, right? Now the board is gonna look at the police FIR and say, you have done very gruesome thing, and I don't think you are a child, and there is only FIR. The version of the child is yet not on record, the evidence has not started, the charge sheet has not been filed. What if the boy goes to the adult court and the adult court conducts the trial and says, you are innocent, but you have sent that boy in jail for so many years by then? So I'm also
As an under trial.
Yeah, as an under trial, at the very beginning, you decide whether he has to be treated as an adult or child. You go to adult court, and then adult court acquits you.
Okay.
Then what do you answer to them? Why did you send that 16-year innocent just based on an FIR? So what I am saying, even if you have to do judicial waiver, at least do it in a fashion so that innocent people don't suffer.
Okay.
Bill is not even thinking about that.
So with so many reservations, and there are arguments also being made that this particular bill also violates certain fundamental rights. Do you think this bill is going to be this law is going to be challenged further in
I
courts?
think so, absolutely. I would challenge it myself.
But your grounds and his grounds will be different.
Different, absolutely. The grounds of the child activists are completely different from the grounds of us as lawyers who think that the kind of problems which this act is not covered, we will want the court to give a judicial decision on that.
And can the court ensure the kind of system that you want in place?
Well, the courts have been monitoring whether there are so many cases the courts monitor, and this would be one of them, whether the mental hospitals or the leprosy patients. I mean, the courts had ever since public interest litigation started, the courts have been monitoring on a day-to-day basis, whether it is CNG or even now pollution. The courts are monitoring, and why can't this be monitored or direction given to all the states to set up the infrastructure in place and the counselling or the correctional home requirements to make sure that a juvenile who comes out of...
What you're seeking now with this particular law could have been sought earlier as well.
Absolutely. That's when we went to the court. This is what was one of the issues taken up by Prayas. I think Prayas took up this issue about the facilities.
So why didn't that work?
Aftercare.
Aftercare.
You know what they have done to aftercare?
What?
In the existing law, there is an aftercare program which covers 18 to 21. So at the age of 18, you are ready to be released, but you have nothing to do in your life. Now the new bill says that one-time financial assistance.
Okay.
So they have reduced the aftercare to one-time financial assistance. So these are also some other critical areas of concern. Why did you eliminate aftercare, which is anyway such a fantastic model of dealing with grown-up person above 18 in the law? You eliminated that also. So what I see is a systematic intention to withdraw a state from child protection, that I don't want to deal with children matter, just leave it. That's how this bad law is coming.
No, but there are child protection laws as well. There's
But they're not implemented at all. See, our courts.
This law itself has a component of how children need to be protected.
Yeah, but we have seen how the JJ Act of 2000 has been implemented in all these years. Had our Supreme Court and High Court not been there, the governments will not just buzz from their chair. They haven't done anything. Whatever has happened in the name of child rights in the country is because of Supreme Court and High Courts. Otherwise, governments don't bother, because children are not politically relevant subject. Nobody loses election because you haven't done anything for children. So all the laws concerning children, not just JJ, any law you name, if it is concerning children, is never on the priority. That's why no implementation, zero implementation.
But if this law were to work, Priya, what do you think would make it workable? What changes are required in the system, and that the governments can do without the prodding of courts?
Well, they have to put the whole infrastructure in place. As I said, a counsellor, a psychiatrist, a person, a whole system of teaching the child, their education level. They have to, the fact that they have to go to school, the fact that they have to be given a set of counselling which would make them understand what they did.
Do you think the governments will be able to find the kind of resources that are required, not just monetary but human as well?
Absolutely. There is no dearth of human resource in our country.
Because you need trained people.
Yeah, trained. Well, they have to do it. They get the money for it. They've got the money for it. 3,000 crores is lying in the Nirbhaya fund. What has the government done? They're still lying unused. So what have they done about it?
Okay.
3 years. I mean, today, that's what was one of the issues taken up in the parliament by one of the speakers, saying, what have you done? Kindly answer us, what have you done with the 3,000 crore fund, which is set up as a Nirbhaya fund?
Okay, do you think that will be a good use of that fund?
I have one more suggestion on that. See, there was a problem, police not registering FIR. What the new laws came, and they said, if the police fails to register FIR, put an FIR on that police officer. That's why now we see cases being registered. Unless you fix state accountability in very clear terms, in this boy, if this boy was not reformed, Supreme Court asked, because everybody was saying boy is not reformed, Supreme Court said who was supposed to reform it? So everybody was running saying, no, I am not government, I am not government. Nobody wanted to say I am government, because the moment you say, that you are government, you also have to take responsibility. What is missing in the laws is that there is no state accountability.
Okay.
If a boy is not reformed, somebody has to tell in the government, tell us why.
No state, I mean, nobody will be willing to take a guarantee that yes, after
No, but then show the effort
spending
at
so much
least.
time in a reformative
No,
Show
but
the
I agree
effort.
with them. There has to be an
the
effort.
person, the
Show the
offender
effort
will be
at least.
For
reformed.
Gautam, there has to be an
Who
effort.
can
There has
guarantee?
to be a system in place. There is no system in place.
But even if the system is in place, I cannot guarantee.
No,
that
but then there is.
you will be reformed.
But you would be showing in these 3 years what have you done.
Yes,
Today
yeah,
they
show.
don't have a
Okay.
report
Yeah.
card to show.
Okay.
They don't have a report card to show that in these 3 years what has been done with this boy. What was the attempt made and what happened? There is no report card.
So until you
They
fix
were not able to
accountability,
produce anything.
this law will not be
So do you feel
implemented.
that that's something that should be a part of a law or should be part of rules?
It would be part of the rules. It has to be
Okay.
part of the rules.
Not
but
necessarily of the law.
no, it does. See, the law again, the amendments which are coming in, as some of them he has pointed out, they are.
This is an altogether new bill.
Yeah,
It
this
would
is
replace the
this
old
is
one.
yeah, this is something which is a reaction to what has happened in these 3 years. Without going into the depth as to
Exactly.
actually what the practical problems on ground level are.
Exactly.
So this is it's a knee-jerk reaction to the Nirbhaya
Okay.
event.
Okay.
So according to me, this is not enough. They are brought in some new aspects, but without realizing that practically they cannot be implemented. They have done away with some things which were good, which had they been implemented as the daycare, as the care system was they were talking, he was talking
Aftercare.
about, that would have worked very well. So, I mean, it's a hodgepodge according to me.
In the name of accountability,
Okay.
all this law has that the National Commission for Protection of Child Rights will monitor the implementation of the Act. Now, National Commission for Protection of Child Rights itself is not functional. It just last month it got the chairperson.
Right.
So you are giving task of monitoring the implementation of such a comprehensive law by a body which itself is struggling to survive. So that shows that really you don't want to actually roll it out. The only provision which will work is judicial waiver. The discretion will be given to boards that you are murderer, rapist, just look at FIR and throw that boy in the jail and then let him rot there and let
He
him.
should be tried. I mean, that's again, it comes back to the system that the court has to.
Trial doesn't take place immediately. Trial also takes some time, and in that period, where will that person be? Will that person
he will be in
judicial custody?
he will be in a remand home.
In a remand home.
He will be in a
That
remand
is
home.
technically judicial custody.
He will be in a remand home. Well, in 3 years, this chap was also in a remand home. He was
Yes.
not allowed to go out. So he would continue to be in a remand home, but he would be tried as an adult. He would be tried under the law, as the other adults would be tried. It's
Okay.
not a question of sending him into where hardened criminal. Of course, that classification, the categorization has to be done, and
Yes.
that's what has to be implemented by the governments.
But that's what the government has said will be done.
Where? They don't say so. They
They've
don't.
said Boston.
No, but the Bostels are not what. Well, let them try and implement it. Let me
Okay.
tell you, it's not going to work. Bostels are not what correctional homes should be.
Okay. Okay.
They're not.
Okay. So clearly, then you feel that a lot needs to be done in this area, and consistent work is required. A lot of systemic changes are required to ensure that we treat offences committed by such criminals of younger age in the manner that a civilized society should.
Yeah, see, first I want that somebody should think through things, So that's why our demand was in the Lok Sabha also we said give it to a select committee and let some people sit
Okay.
together and think. And when the
Okay.
select committee gave the report in Lok Sabha, it also criticized the bill,
Okay.
right? Again in Rajya Sabha, and there were some changes done. So when it came to Rajya Sabha, there were some changes done to show compliance with the Lok Sabha committee. Now again in Rajya Sabha, we again said, don't listen to us, but at least let some people who want to examine and scrutinize the issues in detail, give it to a select committee. Today in the debate, there were a lot of suggestions being given. Now, what is the guarantee that those suggestions will be incorporated by the ministry in the bill?
Okay.
So that's why the select committee sounded the best solution for me, because the nation is divided on the. So somebody has to sit and think. You can't just
Okay.
leave it to the ministry who actually doesn't want to spend much time thinking
Well,
through the
let's
provisions.
see how this law is implemented, and maybe perhaps the need for reform, amendment, and all will be felt in due course if courts don't intervene in the first
Well, I
place.
hope they do.
Let's see what happens. But for now, a long pending demand has been met by our lawmakers, and that is at least movement forward on something, on an issue that have been hanging fire, where justice is at, of course, the root of the concerns of the society. We'll have to wait and see how things are implemented, and we'll be tracking that for you as well. Thanks for watching this evening, and thanks for joining us.
Thank you.
Thank you.